originally we as see, I think for the viewers and for me, there is a music which is coming consistently at the background. I think it is impairing the hearing of the content that we are speaking. I think somebody needs to close the music which is coming from the background. There is a continuous music which is coming from the background.
Sir, closing it down.
Because this is required maybe at the time of waiting. Some people, when the people are waiting, but not at this time when the contents are being spoken. So I think it is now. It's absolutely right now. It's fine now. So when these two judgments will not take that much of time, because see, whatever we say, everyone is now knowing that these are the impact of these are going to be diffused. So we can speak about other judgments on the Supreme Court, and we can also plan another webinar which would be focused on the proposed amendments. I think the Manoj Anandji is passionate about the webinars and collecting all the resources, and like everyone joins him, all kinds of association joins him, so that this organization GPA professional could actually grow to a large extent. I think with this, Manojji, you can start with the some judgments or whatever your thoughts are. And Nireshji, in case you would like to add something on the format of this webinar.
No, it's okay. As you said that because the impact of some of these judgment is going to be reversed. So 1 minute. I think there is 1 minute. One minute.
I think some audio issues with Nileshji. Before he joins us, let me start my deliberation. माय डियर फ्रेंड्स, हमारा आईपा का हमेशा यही ऑब्जेक्टिव होता है कि हम सब लोग जितने भी लोग हैं आपस में मिलकर चलें और जो आईपीएस की प्रॉब्लम है उनको हम हाईलाइट करें और आईपीएस के लिए जो लेटेस्ट इश्यूज हैं हम उन चीजों को वी शुड टेक केयर, यू नो, इन दैट प्रोसेस आई एम स्टार्टिंग माई प्रेजेंटेशन. मेरी प्रेजेंटेशन थोड़ी सी ब्रीफ रहेगी. मैं पर्टिकुलर केसेस को जो मैंने 2-3 शॉर्टलिस्ट करे हैं और उनको एक ब्रॉडर एस्पेक्ट से सब लोगों के साथ शेयर करूंगा. लेकिन जो इंपॉर्टेंट केसेस हैं, जो बड़े केसेस हैं, जब यानी कि जिनकी हमारे को ज्यादा एनलाइटमेंट चाहिए, वो अनिल गोल सर उनको विल टेक केयर. मैंने सिर्फ 2 केसेस चुने हैं बड़े, जिनको मैं थोड़ा सा यानी कि डीपर वे से एनालाइज करूंगा. So that is there. Now let's move to my presentation. This is simply, you know, my personal presentation. Okay. Now let's talk about, you know, first of all IBC-IP इम्पेलमेंट लिस्ट, जो कि हमारे का लास्ट वेबिनार हुआ था. बेसिकली आई जस्ट टेल यू कि जो हमारा लास्ट वेबिनार हुआ होता है 24/12 को हमारा लास्ट वेबिनार हुआ था, उससे लेके आज के डेट तक जितनी भी अपडेट्स हम आईपीएस के लिए रिलेवेंट होती है वो मैं इनिशियली लेता हूं, सो दैट आर आईपीएस के यू नो आर एबल टू गेट समथिंग व्हाटएवर दे रिक्वायर इन नटशेल इन वन ऑफ द मीटिंग. तो हमारे इसके बीच में 3/1/2023 को हमारी एक एज यूजुअल जो 6 महीने का हमारा आईबीपी का एम्पेलमेंट की लिस्ट बाहर आई थी. इसके अंदर फीचर यह था कि इसके अंदर उन्होंने इस बारी जो लास्ट टाइम से चेंजेस हैं वो ये है कि इस बार इन्होंने टोटल नंबर ऑफ कंप्लीटेड असाइनमेंट्स एंड सेक्टोरल एक्सपीरियंस भी दिया को भी डिक्लेयर करा है, नंबरिंग भी दी है इसके अंदर. और जो अर्लियर पहले नंबरिंग होती थी वो उसके अंदर होता था दैट वाज ए यू नो व्हाट वी टेक्निकली नो कॉल इन आर अकाउंटेंसी लीफो. कि जो सबसे लास्ट में एंटर होता था उसका नाम पहले आता था। इस बार ही इन्होंने रिवर्स करा है, जिसने जितनी मैक्सिमम असाइनमेंट्स हैंडल करी हैं उसका नाम दिया हुआ है। तो व्हाट हैज बीन द ऑब्जेक्टिव अलोंग विद द इंडस्ट्री नेम आल्सो। और तीसरा इसके अंदर ये करा है कि सिस्टम विद मैक्सिमम फॉर लीज केसेस में बी एप्लीकेबल। ओके, ये शायद इन्होंने इसलिए करा है कि एनसीईआरटी बेंचेस वर डिमांडिंग कि अगर हम किसी बड़े केसेस को किसी सीनियर आईपीएस को देना चाहते हैं तो हम उसके लिए क्या करें। तो ये इट वाज नॉट समथिंग बिग, बट आई थॉट ऑफ टेकिंग इट इन दिस माय वेबिनार। रीजन फॉर दैट इज कि जो ये मेरा पॉइंट है, मेरा पॉइंट इसके अंदर यह है कि वी हैव बीन ट्राइंग विद आईबीपीआई सिंस लास्ट 3 इयर्स। जो बिकॉज इसके अंदर जो सिस्टम ऐसा है कि हमारी जो है पार्लियामेंट के अंदर इन ए पर्टिकुलर गिवन टाइम ओनली हाफ ऑफ द आईपीज आर एबल टू कम इनटू द इन दिस पार्लियामेंट। रीजन फॉर दैट इज कि जो ये इनकी एएफए की रिक्वायरमेंट होती है, जैसे इस बार की पार्लियामेंट करी तो जिनका एएफए हमारा अलाइव था टिल 30th of June सिर्फ वही आ पाएंगे, और नेक्स्ट जो पार्लियामेंट बनेगा उनका अलाइव जिनका टिल 31 दिसंबर तक होगा वही आ पाएंगे। तो हमने बहुत बारी 3 साल हो गए हम आईबीपीआई से रिक्वेस्ट कर रहे हैं कि भैया कुछ ऐसा सिस्टम अडॉप्ट करिए ताकि सारे के सारे आईपी इसके अंदर जो भी एलिजिबल हैं वो इनके अंदर आ पाए। तो फॉर दैट वी आर हैंडीकैप्ड मोस्टली। शायद हमारी लीडरशिप के अंदर इतना दम नहीं है कि हम आईबीपीआई को इम्प्रेस कर पाए, जब वो हमारी बात को सुन नहीं पा रहे। देयर इज समथिंग इन्वॉल्वमेंट देयर। अगर हम में से कोई आईपी इसके बारे में कोई सजेशन देना चाहता तो प्लीज टेल अस। चलिए, सेकंड डेवलपमेंट जो है हमारे प्रोफेशनल सर्कल के अंदर ये हुई है कि विच
I just want to interrupt for 1 second.
सर शिवनंदा जी वेलकम। आपकी मैंने फोटो नहीं देखी, इस कारण मैं आपको पहचान नहीं पाया। प्लीज वेलकम।
मेरा सजेशन
बताइए,
है
मैं नोट कर रहा हूँ।
कि जो expanded list है, in this expanded list, if the AFA validity date is written, so it will take care, because if you make a panel for 6 months and somebody has AFA for 5 months, the court should not misunderstand. So if you can say that this impanelment, this particular IP will have entitlement. Suppose somebody had AFA up to 30th of May. So had it been mentioned here by including his name, then the court would not allocate him beyond 30th May. Because this chart can be expanded, that till what date the adjudicating authority can appoint that person.
सर योर सजेशन इज रियली वेलकम। हमने इसके बारे में इनको एक सजेशन दिया था। हमने ये कहा था कि अब जो एएफए जो है ना, इसको फाइनेंशियल ईयर वाइज अलॉट करो, यानी कि हर एएफए का अलॉट करो 1 जनवरी से लेकर 31 दिसंबर तक का। जो पहली बारी आप एएफए अलॉट करते हैं, जो नया मेंबर रहता है, उसको मे बी यू कैन अलॉट टिल 31st of December, because we find that as more practical rather than putting it there, because that will make everybody eligible for everything in all the panels। पहली बात। दूसरी बात ये है कि AFA AFA they have taken the AFA, अगर मैं AFA की आपको लॉजिक बताऊं तो they have taken the AFA only with the purpose so that they can have a control, agencies can have a control on us। हम लोग इंस्टीट्यूट ऑफ चार्टर्ड अकाउंटेंट के मेंबर्स हैं, हम लोग CMA के मेंबर हैं, हम लोग CS के मेंबर हैं, वहां पे कुछ इस तरह का कंसेप्ट है नहीं। और अगर we humbly request to our parent institutes, agencies and IBBI, they should have a relook on allocation of AFA। तो सर ये था एक मेरा ओपिनियन। आगे आप बताइए प्लीज।
The view had come that an AFA will be allocated for more than 1 year, maybe 2 years, 3 years, and the validity will go on. So if that happens, then also this problem can be mitigated.
सर वी आर सेइंग लाइक दिस, जैसे अब हमारा चल रहा है जनवरी चल रहा है, तो आज जनवरी की क्या कहते हैं 21 तारीख है, तो जो इस डेट को कोई जो मेंबर बना तो उसकी आप EFA एलोकेट कर दें 21 तारीख से लेकर 31 दिसंबर तक का। नेक्स्ट टाइम जब रिन्यूअल होगा वो अगेन ऑटोमेटिकली 1 जनवरी से लेकर 31 दिसंबर तक का कर दे। तो दिस वी सजेस्ट टू देम। चलिए, इन एनी केस लेट्स मूव टू द सर एनीथिंग एल्स। सर आप कुछ कहना चाहेंगे शिवनंदन जी?
It is fine, but if AFA is given for 2 years, then the problem will also be taken care. So one can apply 3 months before the expiry after 2 years.
चलिए, we noted down your suggestion and in our next meeting we shall do। सर अनिल गोयल सर, आप प्लीज कुछ कहना चाहेंगे इस बारे में?
No, I think let us try to understand the objective of AFA. The objective of AFA is that, first of all, everyone should pay the fee of the IPA. The CPE hours criteria should be met. The kind of, at the time of AFA, just try to understand what all documents they take from you. That you are financially credible, you have completed the CPE hours, you are paying the fee, and there is no SCN issued. So these are the kind of documents they take from you. So in case they do it 2 years, then I believe this actually will not really serve the purpose. And also AFA can be given only to those people who are totally compliant for whatever cases that they have in process. So with this objective, I think the only recommendation that I can see, like Mr. Sharma says, that also it should be mentioned that what is the expiry date of the AFA. If that is mentioned in the IBBI panel, that can be a solution. That can be a solution. That can be recommended to IBBI. I mean, this is not impacting the rights of the IPA to monitor and also to control.
सर जब हमारे गोयल साहब ने अनिल गोयल सर ने कह दिया तो आप ये समझो कि वो पत्थर पे लकीर हो गई. डेफिनेटली सर, आई जस्ट रिमाइंड यू कि हम अनिल गोयल सर के साथ कई बारी अपना यानी कि अपनी एग्जीक्यूटिव्स को लेके आईबीबीआई के साथ मीटिंग करते हैं. तो सर हम इस सजेशन को नेक्स्ट टाइम प्लीज उनको रिक्वेस्ट करेंगे. नाउ लेट मी मूव टू माय सेकंड टॉपिक. ओके, व्हाट आई फील इज दैट कि जब हम लोग लॉट ऑफ मेल्स डू कम टू अस कि ये पब्लिकेशन हो गया, ये वेबिनार हो गया, तो उसके अंदर मैंने 2 पब्लिकेशंस जो इंडियन इंस्टीट्यूट ऑफ इंसॉल्वेंसी एंड प्रोफेशनल एजेंसी के आए हैं, वो मेरे को बड़े अच्छे लगे. उनमें से एक था PG to CD cases, whereas best practices on individual insolvency. तो I would like to enlighten my friends कि आप इसको डाउनलोड कर लीजिए. इसकी डिटेल मैं इसमें दे दूंगा. अगर मैं जाऊंगा तो लिंक पे वो लिंक खुल जाएगा. इनफैक्ट आप भी जाके इजिली इसको खोल सकते हैं. तो इट वाज वन ऑफ द वेरी गुड द पब्लिकेशन बाय द ट्रिपल IPI. और एक उन्होंने वैल्यूएशन का भी दिया. इसको मैंने स्टडी नहीं करा, ये भी काफी अच्छा है. लेकिन जो पहले वाला है PG to CD वाला है, जैसे हम लोगों ने स्टार्टिंग में पीजी के केसेस करने शुरू करे, तो हमारे को ये आइडिया नहीं मिल पा रहा था कि सेक्शन 99 की रिपोर्ट का फॉर्मेट क्या होगा. उसके बाद रीपेमेंट प्लान का जो हम सबमिट करेंगे लेटर ऑन, उसका फॉर्मेट क्या होगा. तो इसके अंदर ये दोनों चीजें बड़ी अच्छी तरह से उन्होंने दी हुई हैं कि किस पर्टिकुलर फॉर्मेट के अंदर ये होगा. तो जो लोग भी पीजी के केसेस कर रहे हैं, जिनके पास आने के लिए है, तो उनको इससे काफी अच्छी हेल्प मिल सकती है. along with lot of cases also there कि जो कि एक अच्छा है. तो ये एक सेकंड मेरी तरफ से सब लोगों को था. ओके, नाउ वी हैव problem of attending CPRs. I should not say problem of attending, but whenever we go for CPRs, so we need to pay it in two terms. One, जो हमारे को वहाँ पे टाइम देना पड़ता है as per the webinar period, or plus other thing also. Plus you have to pay some fees also. That is a quite minimum. 250 रुपया 500 रुपया पर आवर की होती है, और जितने आवर्स होते हैं वो हिसाब से लोग मल्टीप्लाई करके हम लोगों से they do charge from us. But I am telling you, there is a one platform whereby you not only get CPRs but also earn honorarium also. और जो आप CPRs earn करोगे, that is free of cost. What is that? That is triple IPI has come out with a scheme whereby they are allocating 8 CPRs for the each published article therein. वो जो published article है, वो what your number of letters and other things what they have written is that is consist of 6 or 7 pages only. And if you have a good writing skill, जो कि इस स्टेज में आके सबके पास हो जाती है, तो I would say कि you send your article to the triple IPI. They will help you in doing this thing also. और सेकेंडली सेम एक है, आप अपनी मेनू स्क्रिप्ट भी इनको सबमिट कर सकते हैं. ये मैंने उनका एड्रेस दिया है, तो यहाँ पे आप अपलोड कर सकते हैं जो भी आपका आर्टिकल है. एंड इन दैट प्रोसेस, if your article is accepted, you will get 8 CPRs credit also, and maybe some sort of honorarium also. बिकॉज वो कितना है वो मेरे को मैंने करा नहीं। इसके अलावा अब नाउ लेट मी मूव टू द माय नेक्स्ट टॉपिक। ओके, यू नो वी आर अटेंडिंग लॉट ऑफ वेबिनार्स। तो एक वेबिनार मैंने ट्रिपल IPI का अटेंड करा है जिसके अंदर कंप्लायंसेस रिलेटेड वेबिनार बड़ा अच्छा था। इसका लिंक मैं आपको अपनी इस में दे दूंगा। तो ये कंप्लायंसेस जो होते हैं ना, हमेशा चेंजेस होते रहते हैं, और एंड स्पेशली टू दोज पीपल जिनकी पास बहुत अच्छा इंफ्रास्ट्रक्चर नहीं है, जिनके पास हार्डली 1 या 2 असाइनमेंट्स है, और दे आर नॉट अटैच टू द IPE आल्सो। तो उनके लिए यू नो दिस इज समथिंग वेरी गुड। ये एक लिंक है, मैं आई एम शेयरिंग इट द पब्लिक, और इसका पासकोड भी मैं आपके साथ शेयर कर रहा हूँ। तो आप यहाँ पे जाके प्लीज जब भी आपके पास कोई असाइनमेंट आए तो आप यहाँ पे जाके थोड़ा सा अपने आप को अपडेट कर सकते हैं। वैसे आप सब लोगों को असाइनमेंट्स का पता ही है, बट स्टिल यू कैन डू दिस इन देयर। सिमिलरली आई फाउंड another 2 opportunities you know from the triple IPI also। एक अपॉर्चुनिटी उन्होंने दिया मेंटरशिप की। यू नो व्हाट मेंटरशिप इज देयर? मेंटरशिप इज लाइक यू नो यू हैव टू पैनल विद द ट्रिपल IPI। मेंटरशिप का बेनिफिट क्या है? मेंटरशिप का बेनिफिट ये है कि यू नो a mentor who has already done I think 3 number of assignments can always take the services of mentee। mentee mean कि जो एक नया IP बना है तो उसकी सर्विसेज वो ले सकता है। इसकी क्या कंडीशंस है, कैसे है ये प्रोसेस, ये मैं आपको बताता हूँ। मेंटर कैन एंगेज मेंटी IPs। नंबर 2, इसकी रिक्वायरमेंट बहुत सारी और भी है, वो मैं डिटेल में नहीं बताऊंगा, आई एम टेलिंग यू ब्रॉडली। मेंटर मस्ट हैव डन 3 CRP असाइनमेंट्स, और इसका जो टाइम फ्रेम है 6 मंथ्स का टाइम फ्रेम दिया गया है। एंड यू एनी मेंटर कैन हैव यू नो मैक्सिमम 5 मेंटर्स। तो ये भी एक another opportunity है you know for we people, we senior people to engage with the junior triple IPIs also, so that because ये दोनों तरफ बेनिफिट है। इनफैक्ट जब हम लोगों ने आईपा स्टार्ट करी थी तो जो भी हम सीनियर IPs थे तो मैंने उन सबको कहा था कि वी शुड वॉलंटरली एंगेज जूनियर IPs विद अस सो दैट दे गेट द एक्सपीरियंस, और हमारे को भी एक एडिशनल हैंड मिल जाएगा काम करने के लिए। नाउ दिस थिंग हैज बीन लीगलाइज्ड बाय द ट्रिपल IPI, तो प्लीज अवेल दिस थिंग देयर। इसका लिंक जो है ये मैं सॉफ्ट लिंक मैंने दे दिया है, वैसे भी आप इजिली इसको ढूंढ सकते हैं। और इसका पोर्टल पे जाके एक रजिस्ट्रेशन का जो प्रोसेस है वो भी मैंने आपको यहाँ पे शेयर कर दिया है, विच यू कैन टेक फ्रॉम माय सॉफ्ट PPT लेटर ऑन। यू सब्सक्राइब टू आवर यूट्यूब चैनल, वहां पे मेरी सॉफ्ट PPT आपको मिल जाएगी, तो वहां से आप ले सकते हैं। चलिए, 5वां पॉइंट है मेरा आपके साथ शेयर करने वाला, पीयर रिव्यू का। पीयर रिव्यू भी एक नया कंसेप्ट हमारे अब IP के अंदर आया है। एज वी आर वेल, हमारी CA प्रोफेशन के अंदर तो है, तो इसके अंदर जो भी हमारे सीनियर IPs हैं वो पीयर रिव्यूअर बन सकते हैं। इसका मेन इट्स अ वेरी स्मॉल थिंग, इट्स यू नो एलिजिबिलिटी क्राइटेरिया है इसकी, यू मस्ट हैव कंप्लीटेड 4 असाइनमेंट्स एंड मस्ट बी अ मेंबर ऑफ ट्रिपल IPI, शुड हैव अंडरगोन पीयर रिव्यू प्रोग्राम। और भी इसकी थोड़ी बहुत डिटेल्स हैं दैट यू कैन हैव फ्रॉम दिस रजिस्ट्रेशन लिंक and maybe get benefited either you know in the days to come when triple IPI be appointing somebody as a peer reviewer। तो peer reviewer जब भी point होता है you get some remuneration also। Okay, now this is there। My 6th point in my presentation is that ki you know since we people are mainly involved in auditing also as a chartered accountant and as a company secretary compliances of the audit reports also, as a CMA also we are involved with some sort of audit। तो NIFRA जो हमारी audit को controlling authority है, national NFRA, they have come out with you know a sort of ATR for audit firms। तो ये मेरे को बड़ा important लगा, तो I'm thought of sharing with you कि ये basically है क्या। This is basically रिपोर्ट बाय द ऑडिट फर्म्स, ये ENFRA इसका नाम दिया गया है, दैट इज कॉल्ड एनुअल ट्रांसपेरेंसी रिपोर्ट है। इसके एसेंशियल फीचर्स क्या हैं ये मैं आपको बताता हूँ। यू नो नेफ्रा अंडर रूल 8(2) हैज अ पावर टू आस्क फॉर गिव गाइडलाइंस एंड आस्क फॉर सच इंफॉर्मेशन। At present, applicability क्या है? At present, it is applicable to the 1000 public interest entities only, and this is applicable with effect from the 31st March 2023. Public interest entities का मतलब यह है कि ये top 1000 companies as far as market capitalization is concerned, उसकी उनको इसके अंदर लिया गया है, and what they have to do, ये with timing है इसका, within 3 months आपको फाइनेंशियल ईयर के एंड में इसको देना है, और इसके लिए पब्लिक कमेंट्स मांगे कि इसकी रिपोर्ट का कंटेंट क्या होगा, कैसे होगा, इसकी लास्ट डेट 16 फरवरी है, और इसका ऑब्जेक्टिव क्या है, इसका लेट्स अंडरस्टैंड व्हाट द ऑब्जेक्टिव ऑफ नेफ्रा इन आस्किंग फॉर दिस रिपोर्ट. इसका ऑब्जेक्टिव है टू प्रिवेंट conflict of interest of associate firms doing these services. नेफ्रा इज डेडली अगेंस्ट कि ऑडिट फर्म जो है वो नॉन ऑडिट फर्म का काम ना करें, तो इस तरह का, बट पीपल ऑडिट फर्म्स आर डूइंग इट थ्रू सेलिब्रेटेड फर्म्स, तो उस चीज को अवॉइड करने के लिए वन ऑफ देयर रीजन इज देयर कि दे आर आस्किंग फॉर सच रिपोर्ट, और it is meant for basically theoretically for investors, audit committee people, independent directors, and also all of the things here. अब लास्ट बात ये आती है जो मैं आपके साथ ब्रीफली ले रहा हूँ कि इसके अंदर डिस्क्लोजर क्या क्या है. इसके अंदर डिस्क्लोजर करना पड़ेगा आपको ऑनरशिप का, गवर्नेंस का, इंटरनल पॉलिसी का, नेटवर्किंग आपकी क्या है वो, वर्किंग लाइसेंस क्या है वो, कोलैबोरेशन क्या है वो, लाइसेंसिंग अरेंजमेंट है वो क्या, एंड रेवेन्यू रिलेटेड आपका इंडिया से कितना आ रहा है, अब्रॉड से कितना आ रहा है, आपका ऑडिट से कितना आ रहा है, नॉन ऑडिट से कितना आ रहा है. दीज आर दी थिंग्स देयर. ज्यादा डिटेल में आप इसको अगर ध्यान देना चाहते हैं तो प्लीज आई हैव गिवन यू माय लिंक देयर, प्लीज गो एंड सी इट देयर. एंड इसके बारे में ये डिटेल्स के बारे में ये 2 लिंक मैंने आपके लिए रखे हैं, तो प्लीज यू कैन हैव लुक ऑन इट एंड गो देयर. माय 7th पॉइंट इज ओके. ये अभी सर ने अनिल गोयल सर ने भी थोड़ी देर पहले लिया कि इट्स अ वेरी वेरी बिग चेंज इन आर आईबीसी. इन्होंने इनविटेशन ऑफ कमेंट्स मांगे हैं जो कि क्या कहते हैं बैंक्रप्सी कोर्ट के अंदर हैं. लास्ट डेट 18 जनवरी 2023 है, और ये अपने आप में ही बहुत जबरदस्त पॉइंट है. इसको मैं बिल्कुल डिस्कस नहीं करूंगा अभी, बिकॉज अगर हम इसको डिस्कस करने लगे तो इस पर तो पूरा एक वेबिनार चाहिए. आई थिंक 21-22 पेज की जो है, यू गो थ्रू इट, गिव योर कमेंट्स आल्सो. और एक ग्रुप इंसॉल्वेंसी के ऊपर भी रिपोर्ट आ रही है, तो इसके ऊपर भी उन्होंने कमेंट्स मांगे हैं, तो प्लीज गो देयर. Okay, one ninth thing which I find is related to our profession is that SBI has come out with the OTS policy. OTS mean one time settlement policy. तो अब इसकी डिटेल मैं ज्यादा नहीं बता पाऊंगा, मैंने लिंक सॉर्ट दे दिया है, इसमें जाके आप कर सकते हैं. बेसिकली इस पॉलिसी के अंदर जो है वो सिर्फ ये है इसके अंदर कि व्हाट वाज हैपनिंग अर्लियर इज दैट कि जो अमाउंट डिक्लेरेशन के लिए वो मांगते थे, सपोज इफ यू हैव बेसिकली ओटीएस जनरली जितना भी वो करते हैं वो सारा का सारा करते हैं बेस्ड ऑन जो आपकी अंडरलाइंग एसेट की वैल्यू है, सिक्योरिटी की वैल्यू है. तो अर्लियर दे वर डूइंग इट ऑन द बेसिस ऑफ फेयर मार्केट वैल्यू, बट सिडबी ने जो था, सिडबी जो कर रही थी, सिडबी वाज डूइंग इट ऑन द बेसिस ऑफ लिक्विडेशन वैल्यू. तो नाउ दे हैव स्टार्टेड डूइंग ऑन द बेसिस ऑफ लिक्विडेशन वैल्यू आल्सो. ये इनके एसेंशियल फीचर्स हैं. थोड़ा सा टाइम ज्यादा हो रहा है सर मेरा, यानी कि 3:30 3:45 तक था, तो आई एम जस्ट मूविंग बिट फास्ट. तो ये इसके कुछ एसेंशियल इंग्रेडिएंट्स हैं, इससे इंपॉर्टेंट चीजें हैं जो मेरे को और डिस्कस करनी है, तो देन आई बी मूविंग देयर. तो आई एम जस्ट पासिंग आउट व्हाट एसेंशियल कैरेक्टरिस्टिक्स ऑफ दिस थिंग देयर. ओके, नाउ आई एम कमिंग आउट जो हमारा कोर टॉपिक होता है लेटेस्ट जजमेंट्स के ऊपर. तो लेटेस्ट जजमेंट एक मिनट होल्ड करना. लेटेस्ट असेसमेंट में 2 जजमेंट्स लिए हैं। अनिल गोयल सर, ये अगर आपने भी इनको लिया है तो आप प्लीज मेरे को जितना मैं कर लूंगा उनको एनलाइटन कर लेना, आप इसको एक्सक्लूसिवली लेना जैसा आपको ठीक लगे, प्लीज।
आप ले लीजिए,
वी कैन गो इन दैट
आप
वे।
ले लीजिए, मैं अगर कुछ होगा तो ऐड करूंगा, अदरवाइज आप ले लीजिए, उसको मैं मिस कर दूंगा, आप ले लीजिए।
ठीक है सर, थैंक यू वेरी मच। ओके, I'm sharing with you one recent Delhi High Court judgments on avoidance transaction. We have a lot of confusion whereby जब भी हमारी कोई avoidance application जाती है, that we also call it as a PUF application, PUFE, preferential, undervalued, exorbitant और fraudulent transactions related. तो इसके ऊपर we have lot of things to understand कि हमारी जो पफ की एप्लीकेशन है, हमारी जब वो होता ही है कि whenever we are doing CRP cases or maybe that CRP get converted into liquidation case, तो जो पफ की ट्रांसैक्शंस जो होती है हमारे CRP भी खत्म हो जाती है, लिक्विडेशन भी खत्म हो जाता है। अब पफ ट्रांसैक्शंस जो अवॉइडेंस ट्रांसैक्शंस के अंदर जो हाउ टू प्रोसीड विद दैट, कि whose responsibility is to do with it. सेकंड क्वेश्चन कम्स कि अगर वहां से कुछ हमारे को कुछ अमाउंट मिलता है, जब प्रोसीड्स मिलती हैं, तो उनको हम कैसे हैंडल करेंगे। तो आरपी की या लिक्विडिटी की रिस्पॉन्सिबिलिटी कहाँ तक है उन ट्रांसैक्शंस को करने के लिए। तो ये पूरी इसकी जो एसेंशियल फीचर है, जो उसकी मैंने पॉइंट्स इसके अंदर ढूंढे हैं, वो मैं आपके साथ एक एक मिलकर साथ शेयर कर रहा हूँ। पहला पॉइंट इसके अंदर कंक्लूजन दिल्ली हाईकोर्ट ने ये दिया है इन द केस ऑफ टाटा स्टील बीएसएल लिमिटेड वर्सेस वीनस रिक्रूटर्स प्राइवेट लिमिटेड एंड अदर्स, दैट NCLT and NCLT can here adjudicate on avoidance application, notwithstanding that the CRP has concluded. Meaning thereby, this adjudication can be done parallelly. Second is that, what they have written in the order is that CRIP is a time-bound process, whereas the avoidance application proceedings require a proper discovery of suspect transactions that are to be avoided by the adjudicating authority. Accordingly, adjudication of an avoidance application is independent of the resolution of the CD and can survive CIRP. Third is avoidance application can be filled even after the registration plan filed with the AA until the approval of the plan. If such application filed before the registration plan submission to the AO, then that should also be incorporated in the plan, or otherwise EOA, otherwise adjudicating authority may direct the treatment as it is necessary. This is a very vital point. I think we people IP should take care and must have understood this thing. Fourth point is that RP will not be a functious official for pursuing avoidance application and can continue to pursue such application. The method and manner of RP remuneration have to be decided by the AA itself. ये भी एक बड़ा इशू होता था कि लिक्विडेशन प्रोसेस खत्म हो गया, तो जब सीआरपी खत्म हो गई तो उसको परस्यू कौन करेगा, उसकी फीस कौन पे करेगा। दिल्ली हाई कोर्ट हैज कम आउट वेरी क्लियरली अगेंस्ट इट. My fifth point in this is that money borrowed from creditor, this is a very vital point, try to understand it. Money borrowed from a creditor is essentially public money, and the same can't be appropriated by private parties by way of suspect arrangements. Any benefit accrues out of avoidance application must be for the benefit of creditors of the erstwhile corporate debtor. It is apt that any kind of benefit accrued from the adjudication of avoidance application in cases where treatment of such application could not be accounted in the plan must be given to the creditors of the erstwhile CD. इसके ऊपर एनसीएलटी की काफी कंफ्लिक्टेड जजमेंट थी कि जो प्रोसीड्स मिलेंगे उनका कैसे करेंगे. दिल्ली हाई कोर्ट हैज कम आउट with this thing. Against it, my sixth point is that amount made available by the adjudication of avoidance transaction can't go to the kitty of resident applicant or to the corporate debtor in its new avatar, since it does not continue as a debtor and has gone through the process of resolution. This amount should be made available to the creditors who are primarily financial institutions and have taken haircut in agreeing to accept a lesser amount than what was due and payable to them. They have given the logic for that also, why this amount should go to the CD. और इसके अंदर last मेरा जो है point है, proceedings out of the avoidance applications can be distributed amongst the secured creditors in accordance with law as determined by the NCLT. तो एक ये इन्होंने इशू क्लैरिफाई करा है। तो सर इस पर्टिकुलर जजमेंट के अगेंस्ट फेवर, यानी इसमें कुछ और हमारा कोई आईपी ब्रदर ऐड करना चाहे, या अनिल सर आप ऐड करना चाहें तो प्लीज एनलाइटन अस।
I think this is again the Venus Recruiter judgment earlier from Delhi High Court, where the confusion was created like the RP cannot wear the hat of a former RP. And then in that case, all the applications submitted by RP after the resolution plan was approved, that was rejected. So now the clarity, in fact, this clarity has also been seen in the modified regulations. Almost it is a similar clarity which has come in a High Court judgment also. So now the clarity that all of us must have in mind is that the perfect transactions are separate applications. There should be separate application for section 43, 45, 49, 50, 66. And even it is recommended that for such larger transactions, we file separate application for a faster adjudication. Otherwise, in case we make 12 transactions in one application, then the respondents would be 12 and the decision would be very difficult. So for some larger transactions, the separate applications can be filed. So I would not mind in case there are 6 or 7 or 8 applications in one case. So that is what is the kind of intent of the legislature for faster adjudication. Secondly, the resolution plan can be approved, and whatever applications has been filed by the RP, that will actually be informed to all the prospective resolution applicants, so that they can accordingly consider those and factor in their resolution plans. However, the resolution plan will decide whether the proceeds of any perfect transaction will go to creditors or it will go to successful resolution applicant. That would be something which will be which should be monitored through the resolution plan. So with these additions, I think this Tata Steel BSL Limited, which is the Bhushan Steel Limited, erstwhile Bhushan Steel Limited versus Venus Recruiters Private Limited. Earlier judgment was also same, but it was, I still couldn't understand why this judgment has come from Delhi High Court. Earlier judgment was also from Delhi High Court, and that was also in this case. So Manojji, in case you have gone through this judgment clearly, why this is a judgment with dated 13th of January 23? Earlier judgment was also Venus Recruiter. That was also in the case of Bhushan Steel Limited.
Anilji, actually earlier that was a single judge judgment, and it is against that order. Appeal was filed before the division bench, and then this order has come.
So I think this is more or less the clarity. Earlier, the RP will not be functus official for pursuing the avoidance application and can continue to pursue such applications. The method and manner of the RP denomination ought to be decided by the adjudicating authority itself. All this is, I think, very, very welcome move. So the RP, most of the RPs were struggling because they have remitted the office back to the successful resolution applicant, and still they are struggling to fight the perfect transactions. Even in liquidation also, we are doing the same thing, but then in resolution process, we can still have this now the very nice alternative that even the remuneration will be decided by the adjudicating authority, as you are indicating, Manojji. So Nileshji, I think this judgment needs some more information. If Manojji and me is missing on anything, because you seems to be somehow part of this judgment, or you might have read this. Somehow I have not read this judgment so far, and I have read the earlier one. So what exactly the difference this judgment is making as against the single bench judgment of Venus Recruiter?
Okay, I think one important thing is that they say that in the earlier judgment said that the NCLT has to first decide these PUFE applications and then pass the order for approval of a resolution plan. And if before approval of a resolution plan it is not done, then then it can't be done. So this type of view was there of Honorable Delhi High Court in that particular order. Now they say that avoidance application, adjudication of avoidance application will be taking some time, because here this type of transactions have to be proved by adducing the evidences and all. So this process will be taking much more time. So resolution plan approval process should not wait for adjudication of these applications, and then authorities should adjudicating authority should proceed with approval of resolution plan. And if for any reason this application is not decided prior to that, then it can still continue after approval of resolution plan. And if for any reason the application has not been filed prior to completion of CIRP process, it can still be filed. So this is one thing. And another important thing what they say is that RP does not become functus officio. I think here I'm having some having some reservation, and that is that once resolution plan is approved and then company is handed over to the resolution applicant, after that we are expecting, and record is also handed over to the resolution applicant who has taken over the company. At this stage, if we expect RP to continue with these proceedings, I think it will be difficult for him, though the judgment says that his fees will be decided, but still I think it will be difficult for him. So according to me, the beneficiary, whosoever is the beneficiary in the resolution plan, normally we have to provide that who will be the beneficiary of the funds. Okay, so once the beneficiary is decided in the resolution plan, suppose the plan says that RA will be the beneficiary. Okay, so then in that case, or the CD will be the beneficiary, because through CD, RA will only be getting that money. In that case, the CD has to continue with this. Even for the financial creditors, it will be difficult to continue with these proceedings. If suppose the beneficiary is declared as the secured financial creditor or financial creditor, how would they continue with this? Because they would not be having the relevant record, which will be required for the purpose of giving evidences and all. And then the beneficiary only will be interested if suppose beneficiary is the lenders, and the company is in possession of information, or CD is in possession of information. Then in that case, CD may not be interested in continuing these proceedings, because he is not going to get any benefit. Okay, so according to me, ultimately, whenever resolution plans are there and secured creditors, they decide as to how much money should be paid to them. So they will be keeping in mind the money which will be realized from these transactions also. Okay, so they are charging their price. So ultimately, according to me, this money should go to the CD only. Okay, because RA has paid the price for the same. But this particular judgment says that no, the money should go to the financial creditors or to the creditors, because the money, it was public money which has been siphoned away. But these creditors, they have taken, while deciding about the resolution plan, they have considered that yes, there is some money, though it will be discounted considering that uncertainty is there. But still, I think they know that this much of money has been taken away by the group companies in the form of preferential transaction or undervalued transaction. I think definitely they should consider it. And then, so one, this particular complication that RP does not become functus officio, he will be paid the fee and he should continue with these proceedings. I think it will be difficult for him.
Thank you very much.
जी, I agree with you. इसके अंदर सर आप कहना चाहते हैं कुछ, प्लीज कहिए.
I just wanted to thank Nilesh ji for adding this. I think over to you, Manoj ji.
But Nilesh ji, they have not said that the RP must continue to pursue it. He can. They say that if the decision is that the RP should pursue because he knows the background of the matter, but there is no condition that he must do it.
The judgment says so, Shivnandan ji. Mr. Sharma, the judgment says so. I think, can you go to the previous slide, Manoj ji, of this judgment? previous slides.
Even otherwise, if an applicant is RP has to continue as an applicant. And in case RP doesn't want to continue, then who would be replaced at the place of RP? So that's a condition, because see, either the creditors will take the lien, the creditors will take the assignment, or the RP will continue. So most probably, practically, the RP will continue as the applicant.
Anilji, he's the applicant, but he's doing it actually on behalf of the CD. So he's in the capacity of an RP of the CD. He has filed this application. But once he hands over,
my understanding is that it is nowhere written in the law. It is nowhere written in the law that the proceeds of perfect transactions will go to creditors. And in case you would see in section 43, the whatever recovery will come from the preferred creditor, that recovery will come to the company, and then it is the decision of the company or the resolution plan or the RP how to allocate this money and to whom to distribute. Similarly, under the undervalued transactions also, if the section clearly says that either the transaction will be reversed or a compensation will be taken from the beneficiary of the undervalued transactions. So this will also come to the company. And in case we see section 66, it is also very clear that the contributories, the people who have caused loss to the company, they will contribute to the company. So all these three sections very clearly say that either the property will come back to the company, or the difference will come back to the company, or the entire amount of the fraud will come back to the company. So it is only because of the resolution plan, whatever we write in the resolution plan, it might even be given to the creditors. So, however, the law situation is very clear that it actually belongs to the company. So the creditors, in fact, what RP is doing, RP is not doing it on behalf of the creditors. Why I am saying so? That the RP doesn't need any approval from the committee of creditors for filing any application under section 43, 45, 49, 50 or 66, other than the legal counsel, fee of the legal counsel. Otherwise, this is an independent affair of the RP. RP is doing a job based on the regulations and based on the law. It is his obligation to do this. So RP in these cases is not at all directed by the COC. It is the duty of the RP to do this, and the money realization as per the law, it will go to the company, and as per the resolution plan, it can change whatever the COC decides.
Okay, Anilji, in this regard, we know that money actually has been siphoned away from the company and money has to come back in the company. No doubt about that. But as you know that as per the regulations, prevailing regulations, in the resolution plan, we have to mention as to who will be the beneficiary of this money, which will be coming out of these proceedings. So we have to mention very clearly in the resolution plan whether this money will be going to the creditors as and when it is recovered by the company, or it will be retained by the company. And then also we have to mention in the resolution plan as to how the proceedings will be conducted, as to who will be responsible for continuation or pursuing these proceedings and who will be bearing these costs. So in most of the cases, what we are writing.
Can you read the point number 4 at the bottom?
1 minute.
Can continue.
1 minute, Mr. Sharma. So in most of the cases, Anilji, what we are doing is that we are providing in the resolution plans that secured creditors, they will be the beneficiary of the money which is ultimately recovered. I think in your cases also, similar kind of provisions must be there, or in some cases they say that 50% or like that.
That is based on the practical experiences, based on one fact that the resolution applicant has not factored in any proceeds from these transactions because of the delay in the transaction process, the application process.
And uncertainty which is there.
And the uncertainty. And secondly, yes. If anyone has not factored into the price that he's paying, then he should not be enriched. Undue enrichment, it should not be there. So therefore, every COC has decided that this proceeds of any transaction will come to the creditors.
will come to the creditors. So this is one, and this particular, but at the same time, this is the we have to mention in the resolution plan. So it is not that there is a law that is money has to go. Logically, what you are saying is correct, but resolution applicant or a resolution plan can provide that I am giving to the secured creditor such and such amount, or whatever decided amount, whatever money finally comes out of these spoofy transaction will belong to the resolution applicant, or will belong to the CD under the control of resolution applicant. So even that provision is also permissible under law. So
Yes,
this
absolutely.
flexibility is there. The money can go to secured creditors, or money can go
So
to
this is the, no, I think, see what I was trying to say. So this is the original provisions in the law that the money will come to the company. Money will come
Correct.
to the CD. Now, if
Right.
the money is coming to the CD and by that time the CD is already in the control and custody of a new management, then it will remain with the new management unless it is mentioned in the RP, unless it is
Right.
mentioned in the resolution plan.
Correct. Now this judgment says that this money belongs to the secured creditor. So this money should go to them. And I think it is also saying that if resolution plan is silent about it. Okay,
No,
so if
this is a particular case where the resolution plan was not having anything. So then they are deciding that they have decided this issue based on one, that the resolution applicant did not factor into all these issues into the resolution plan. So there should not be any undue enrichment to any other person. Secondly, the resolution plan did not mention whether it belongs to X or Y. So therefore, the benefit of doubt goes to the creditors and not to the resolution applicant.
okay, so even if resolution plan is silent, as per law, the money should go to the corporate debtor only, because money belongs to the corporate debtor, so it will come back to.
That is what is the law. That is what is the law.
Correct. But this High Court judgment says that in that case, money should belong to the secured creditor only. So this is one thing. And another thing is that the RP does not become functus officio, and he can continue, and then in that case he will be entitled to the fee. So this is, I think this is the
The point is can continue.
yes.
Because in my personal cases, I have even refused to be the part of monitoring committee, even when the plan said that the RP will be in the monitoring committee, because depending upon the headaches and other issues, I have refused to become the monitoring committee member, because as far as I am concerned, my role is over the day the plan is approved. Except if there are any appeals or anything which I have to defend, where I am made party, my role is over.
Sir, I think we need to discuss other things also.
Yeah.
Correct. We move on to the next.
So can we move to another judgment, sir? Sir, अनिल गोयल जी, आप ही के पास कम टाइम मिलेगा, हमने आपको ज्यादा सुनना है. So in fact, I would like to end discussion on this judgment with the permission of all.
Manoj sir, 1 second. Manoj sir, this is PT Joy.
Yeah.
Sir, another judgment in this regard, no recent judgment, it is this Aditya Kumar versus Om Prakash Pandey, which is an enclave judgment,
Yes.
Ashok Bhushan judgment, which very clearly says under regulation 35A, the time limits, forming an opinion within 75 days as to the avoidance transaction, then determination of the transaction within 115 days, then submitting the avoidance petition within 130 days. Very clearly it says they are only directory, because it further says that if we stick on to the time limits under regulation 35A, many of the PUFE transactions will remain undetected. This is the wording used in the judgment.
No, I think I have read that judgment, and that is also a welcome judgment, because most of the resolution professionals were finding it difficulty to meet the timelines. Reason number one, 19.2 application is not disposed of or is not effective.
Yeah.
Number two, the promoters are not providing information. Number three, the auditors are not able to complete the audit. Number four, the books of accounts are not ready, and the books of accounts are being restructured from the bank accounts. The bank accounts doesn't provide information which is required. So all these reasons were explained to the appellate authority, and this judgment is a welcome judgment.
Sir, even in this judgment, if you read the dates, the application for PUFE was filed after 120 days, after the filing of plan even. If you read in the order of Venus, the PUFE application was filed late.
In this case, the application was filed even after the resolution plan was submitted to the NCLT.
Yes.
After approval of the COC.
Thank you very much. In fact, judgment तो दी थी Honorable Chief Justice Satish Kumar Chandra Sharma ji ने और along with Subramanian Prasad ji ने. But in our this small webinar, Nilesh ji, Anil ji, and PT Joy ji and Shivnandan Sharma ji, आप अपनी फोटो जरा ऑन कर लीजिए. हम आपकी बात करते करते आपको देखना भी चाहते हैं.
My camera is not
you have been
working.
our
My camera
okay.
is not working, and I can even offer that in case you have any views, then I can in private discuss the views with the people who have given this judgment.
ओके 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 मैं तो अपने ऑडियंस को बता दूं, हमारे शिवनंदन शर्मा जी दिल्ली से बिलोंग करते हैं. ही इज अ वेरी वेरी सीनियर सीए एंड आईपी आल्सो एंड वेरी वेरी क्लोज फ्रेंड ऑफ ऑल ऑफ अस. अनिल जी के भी, मेरे भी और नीलेश जी के भी हैं. तो सर अगर आप परमिट करें तो मैं सब चीजों को समराइज कर दूं इस जजमेंट के, एंड देन वी मूव टू द फर्दर. Okay, I'm sharing with my all audience. कहने का मतलब यह है कि law clearly provides कि जो भी proceeds इस perfect transaction से आएंगी, it will belong to the CD. But this judgment said that since haircut has been taken by the financial creditors, तो ये proceeds उनको दी जाएंगी. और as far as rest of the procedure aspects are concerned, कि वो continue रहेगा, कुछ रहेगा, उसके अंदर कोई confusion नहीं है और ना ही कोई discussion हुआ है. और मिस्टर पीडी जॉय ने हमारे को थोड़ा सा और एनलाइटन कर दिया कि जितनी भी ये टाइम लेम्स इसके लिए प्रिस्क्राइब करी गई है रेगुलेशन के अंदर, केरला हाई कोर्ट हैज कम आउट विद डिसीजन कि दीज आर डायरेक्टरी इन नेचर. तो that is a sort of relief to us. नंबर वन बात. और सर दूसरी बात इसके अंदर मैं ये would like to deliberate कि since it is a Delhi High Court judgment, applicability legally it should be only on the Delhi jurisdiction. But many a times अगर कोई judgment beneficiary होता है और एक high court करता है तो rest of the high courts also do follow it up. With this, I respectfully end my discussion.
Anand sir, the judgment which I said, it is NCLAT principal bench. It's not Kerala High Court.
It's NCLAT principal bench. Okay, but okay, NCLAT principal bench. तो NCLAT principal bench की judgment है वो तो वैसे ही हर IP के ऊपर applicable हो गई. Sir, with the kind consent of everybody, should I move to next this thing?
Yes, please go ahead.
Next judgment.
Yes, please go ahead. Yes, please go ahead.
Okay. I have taken one recent judgment of Hirakon Industrial Works Limited. This is a something very very unique judgment where practically what happened कि section 7 की application file करेगी, resolution plan आया, and every thing was cleared by the concerned NCLT also. But somehow one of the disgruntled creditor or stakeholder filed an appeal with the NCLT. He summarized the whole case and said that this is a sham transaction. जो section 7 की application file करेगी वो भी sham है, जो resolution plan करा गया उसके अंदर related parties का involvement थी वो भी sham है. NCLT in my opinion, सर अनिल सर नीलेश जी आप मेरे को एलाइटन कर सकते हैं, तो उन्होंने पूरी की पूरी प्रोसीडिंग्स को जो था नलिफाई कर दिया. मेरी नॉलेज के अंदर ये इस तरह की पहली जजमेंट थी. तो बिफोर आई मूव इनटू सबरी डिटेल्स, प्लीज ऐड फ्रॉम योर साइड सर.
No, I think I have not gone through this judgment. Maybe Nilesh ji can do some justice to your question. However, what I understand is that if a particular process has been conducted fraudulently and it has been somehow ignored or not noticed by NCLT, and then in such cases, the NCLT can always pass an order that the original admission of the CIRP was also in connivance, it was fraudulent, it was with the objectives which are not the main objectives of the IBC. Secondly, the resolution process was also conducted with the related parties in the COC. Third, the resolution plan was also approved by the related parties. So therefore, the entire process can be considered as unlawful and the company can go back to the main promoters without any resolution. So the creditors will have options provided under the law. So this, in any case, there are other cases also where I have seen those cases where the liquidation process continued for 1 year, and thereafter it was decided by NCLAT that the entire process of CIRP was conducted fraudulently with the related parties, and all these decisions were taken by related parties. So the judgment was passed where it was directed to NCLT that the resolution process may be started again, the RP may be changed, and the resolution may be found with the new RP. So those kind of judgments we have seen. In fact, we were appointed at the second inning of this CIRP as RP, and we have now found the resolution for that company for 500 crores. So these are various examples available. And the original RP who conducted, he was suspended for 2 years.
Okay. Yes, sir. Nilesh, please.
So, Anilji, in this particular case, what has happened is that I think Odisha High Court order for auction of the assets of that particular company for recovery of the workers' dues to the extent of 45 crore or something. And then in the meanwhile, I think already there was some application which was pending, and the creditors, they requested for early admission of the case. Application was admitted, proceedings continued, and then subsequently it has been it was requested to the court that these proceedings were actually fraudulent in nature, and then objective was to defeat the action which was required, which was initiated by Honorable High Court of Odisha. So actually, in this type of a situation, when a court, through the court, some recovery proceedings have been initiated at this stage, if suppose some creditor goes to the NCLT and gets the application admitted, so is it a fraudulent transaction? According to me, no, it is not a fraudulent transaction. Because if that 66 crore rupees thing is there, if suppose High Court orders for sale of these assets, and then this money is distributed to these particular creditors, workers, okay, and still the secured creditor or other creditors who are entitled under Section 53 for major amount of this sale proceeds. So if they initiate this type of action, I don't think that it is a fraudulent kind of proceedings, because if a company is not able to pay its debt, okay, and a court orders for recovery through this mechanism, I think that is not that ultimately this transaction will also be treated as a preferential transaction, because these creditors, these workers, they are not entitled to this money under Section 53. If suppose these assets are sold, money is paid to the workers, and then after that this 7 application is admitted, and then RP will be under an obligation to determine whether there is any preferential transaction. Definitely this will be treated as a preferential transaction, because these workers, they become entitled to only 10% of this, or in the same ratio. For the last 24 months, they have that first pari passu charge along with the secured creditors, so they may be much lesser. They may not be entitled to 100% of the dues. So in preferential transaction, if you have made any recovery through the mechanism of a court, even then the transaction can be treated as a preferential transaction. But I think most of us are having this opinion, or most of us we are having this impression that in this type of a situation, suppose a corporate debtor also initiate these proceedings under Section 10. So we say that he's doing it for the purpose of fraudulently getting benefit of waiver of liabilities, but I don't think so. According to me, under section 66, he is having an obligation. Whenever he is not in a position to pay his debt, then the company must be referred to insolvency process, and this is in place of recovery through this kind of mechanism. I think the asset should be utilized for the through the insolvency process for the benefit of all. So this is one thing. Second is that whether if any fraud has been committed, if any fraud, I don't call this as a fraud, but if suppose any fraud has been committed, then the court, if suppose on NCLT a fraud has been committed, NCLT itself is entitled to reverse that order. If subsequently it comes to their notice that there has been a fraud which has been through which an order has been obtained, then every court is entitled under law to reverse that, to nullify that. Okay.
नीलेश जी, सर, with your kind consent, 4:15 अभी हो गए, अनिल जी ने अभी स्टार्ट नहीं करा. मैं
I will like to take 1 second.
I just continue.
I would like to take
Yes,
1
Shivnandan
second.
जी क्या कहना चाहते, please.
Congratulations that you recovered 500 crores in a particular matter. I would like to mention Nilesh ji's one point, that there is a section 65 here which says that in case the CIRP or liquidation is fraudulently done, then there is a penalty. So if any promoter designs and goes for section 10 after designing, then in my view, RP in any case has a duty that is the CIRP commenced fraudulently or no. I have recently filed a section 65 application as an RP against the operational creditor who took it as a recovery suit. So I have gone to the adjudicating authority that an operational creditor cannot misuse as a recovery suit. Please start 65 proceedings. I would not like to be RP in such companies, and section 65 application suo motu filed by me. So
Sure.
I think section 10, you can't fraudulently plan.
So what is fraud there if you are filing an application for
Sir,
initiation?
आप शुरू से कंपनी में चोरी कर रहे हो, कंपनी को बिल्ड अप कर रहे
Sorry,
हो,
sir.
then after 3 years you are doing
Sharma,
that.
1 minute, Sharma ji, kindly understand. When you are referring the matter to a court for initiation of insolvency, where is the fraud? Where is the fraud? If first of all, you are handing over the assets of the company to the resolution IRP who will be appointed, then if you have committed a fraud, then RP will be conducting an audit, and he will be determining all the transactions of siphoning away of money. So I don't think referring a matter to NCLT under section 10 can be a matter of fraud.
No, I think, Nilesh, I would like to add, first of all, I would like to agree with Shivnandan Sharma ji that there is a section 65, not section 60 subsection 5. There is a section 65 which talks
Correct.
about fraudulent or malicious initiation of proceedings. Now, how this section reads: if any person initiates the insolvency resolution process or liquidation proceedings fraudulently or with the malicious intent for any purpose other than the resolution of the insolvency or liquidation, as the case may be, the adjudicating authority may impose upon such person a penalty which shall not be less than ₹1 lakh and but may extend to 1 crore rupees. Subsection 2, if any person initiates voluntary liquidation proceedings with the intent to defraud any person, the adjudicating authority may impose upon such person a penalty which shall not be less than 1 lakh rupees but may extend to 1 crore. But I don't think there is any possibility that anyone can submit an application under section 65. This is the powers with the adjudicating authority, that in case they find any application with this intent, then they can actually reject along with the penalty. However, the new proposed amendments are giving much larger powers to the adjudicating authority for imposing penalties which may even run into crores, and that would be 3 times the kind of benefit taken or kind of loss caused. So these are this provision, I think, Mr. Shivnandan, but then I couldn't see that any person can file an application under section 65. You can only argue before the adjudicating authority that this is a fraudulent application, and the adjudicating authority may use its powers to reject and also apply a penalty. That's what
Absolutely right. But RP can say that it looks like that, kindly review and take the action.
So,
No,
but
I
under what
think,
situation? What situation and
I
application?
am saying, I may repeat that the RP doesn't have a power to file an application under section 65 because there is no section which actually says, yes, the RP cannot file an application under section 65. This is what is my opinion. It is the powers with the adjudicating authority only.
Sir, section 60, subsection 5 application requesting the AA to look at it under section 65.
I think that can still be done, but then the RP is doing it. I think that's really wonderful. What happened to RP, how the RP feels that it is fraudulent, that is something which is to be, which is based on facts. We can't comment on that.
Sir, we have a lot of discussion on this judgment also. In fact, मैंने इसका एक brief बनाया हुआ था कि इस केस के अंदर क्या हुआ, कैसे हुआ. अब उस brief को मैं नहीं पढ़ रहा because we have already consumed a lot of time. And इसका मैं, you know, in nutshell, मैं यही बता रहा हूँ कि इस निलेजी जैसा आपने कहा उसके accordingly इस particular case के अंदर NCLT ने ये you know stance लिया. उन्होंने ये ना what happened, उन्होंने कहा कि ये जो section 7 की जो application file करी गई थी, it was filed with the malafide intention. वो वाले जो facts थे was not brought at the notice of the NCLT at the time of filing of the application. Later on, जो COC form करेगी, वो भी, you know, it was formed with related party people, which was bad in law. RP should have noted that thing, and the objective of that particular formation of COC was also to, you know, provide some extraordinary benefit to a particular the class, at the cost of, you know, not providing that particular benefit to the workers. जो 42 crore के करीब उनके dues थे, and you know the NCLT you know clubbed all this thing and came out with the conclusion that this is a you know sham transaction since beginning. Hence, I'm questioning, you know, despite the passing of all registration plan and buying of the company by a successful resident applicant, I'm questioning everything. And, you know, as usual, it happens, wrote to the IBBI that yeah, his conduct should be investigated thoroughly. अब उसका conduct जो भी concerned RP था, what will happen with that RP, only time will tell. And at the same time, अनिल जी जो आप कह रहे थे section 55 के अंदर, उन्होंने स्टेक होल्डर्स के ऊपर पेनल्टी भी लगाई, आई थिंक 50-60 लाख रुपए की शायद सीडी या पर्टिकुलर बेनिफिशियरी फाइनेंशियल क्राइटेरिया के ऊपर. तो हीरोकन इंडस्ट्रीज की जजमेंट का दिस वाज इन नटशेल एवरीथिंग. तो इफ परमिटेड तो सर आई मूव टू नेक्स्ट माय जजमेंट.
Yes,
I think we should I think you have to give time to Anil ji also.
Yeah, that is why sir,
I have another assignment of, I have another webinar at, I think Nilesh ji is also there in that webinar. I think Mr. Madan is there. And that's like the National Law University is also conducting. So that starts at 5:30 and I have a meeting at 5 o'clock. So I will finish by 5. And we actually, the various judgments that has actually come in year 2022, I will run through those judgments. And all those judgments where the impact is being diffused, we will just quickly run through. But in the meantime, whatever you want to say, Manoj ji, please continue and I will manage, no problem.
Okay, you know, my next judgment is, I'm not able to share my screen, but I think it is not coming. Something went wrong with in between my doing this thing that I'm not able to share my. Is it visible now?
It is visible. Like, you know, we can read this
Okay.
urban infrastructure.
Yeah. Okay. Now, you know, sir, seeing the totality of all circumstances, मैं थोड़ी सी अपनी judgments को काफी fast move करने की कोशिश करूँगा so that we can have listen from Anil ji. Okay. I have already discussed my two judgments.
Manoj ji, ऐसा कर लीजिए ना. I think Anil ji is here till 5 o'clock. So you can restart after 5 na? ये वाली remaining.
Yeah, absolutely very good suggestion.
अनिल जी
सर आप प्लीज, अनिल जी प्लीज आप क्या कर ले, स्टार्ट कर लीजिए, हम लोग आपस में बाद में कर लेंगे, या मैं भी यही सोच रहा था। बिल्कुल बिल्कुल सही सर, प्लीज स्टार्ट शेयरिंग, आई स्टॉप माय स्क्रीन शेयरिंग, आप प्लीज अपनी स्क्रीन शेयरिंग स्टार्ट कर लीजिए।
श्योर श्योर श्योर। आप स्टॉप शेयर करेंगे अभी?
आप अपना
स्टॉप कर लीजिए, ये
आप स्टॉप शेयर करो ना।
हाँ सर मैं कर रहा हूँ, वो मेरा आई गेट स्टक अप समवेयर, आई एम नॉट एबल टू स्टॉप इट, माय आइकॉन इज नॉट कमिंग आउट टू बी देयर फॉर स्टॉपिंग ऑफ द। सर आप you start verbally, I be able to
I can
stop
do
it
that
in
for
between.
you. I will.
You can do for me, yeah. Chandan, कैसे होगी इसमें? Oh, sorry. Is that okay? I'm able to stop now.
I think yes.
Sir, please.
So there are many judgments on the Supreme Court in the year 2022. That's what is the subject that we had today. And however, we only would be able to take a few ones, and that too hurriedly. In fact, let's try to see the kind of judgments. There are various subjects that we have, and you can see on the screen. So the financial and operational creditors, withdrawal of CIRP, resolution plan, personal guarantors, moratorium, and all these are the kind of various judgments. Now, Vidarbha Industries Power Limited, I will just take only 1 minute on this. This is a judgment which came on 12th of June, and then it was also a review also came for this judgment. And in this judgment, it was the facts were totally different. The company had a kind of arbitration award in its favor, and that award was also an appeal was filed by the counterparty, and that was also pending with the Supreme Court. So it was argued before the Supreme Court that in case 1,746 crores are given to this company is solvent, and the company will be able to meet all its financial obligations. So based on this, the amount was 1,730. Based on this, the Honorable Supreme Court said that it is not necessary that all applications under Section 7 may be admitted to CIRP, because the word used there is may and it is not shall, unlike Section 9 applications. So therefore, the court said that this is the entire CIRP process is kind of quashed, and there is a possibility to look into other aspects also, other aspects of insolvency or solvency, and then only the CIRP should be admitted. So this kind of judgments, in fact, there were some more cases which NCLT had started giving judgments, and the judgments were in fact based on the again Axis Bank versus Vidarbha Industries Power Limited, and this was again on 22nd of September 22. The review petition was also submitted. In the review petition, it was held by the Supreme Court. It was held by the Supreme Court. So in the review petition, I will just give you what was finally held. In the review petition, it was held by Supreme Court that Section 7, subsection 5, clause A of the IBC provides that where the adjudicating authority is satisfied that a default has occurred and the application under subsection 2 of the IBC is complete and there is no disciplinary proceedings against the proposed resolution professional, it may by order admit such application. So the word may was highlighted. It is well settled that the judgments and observations in the judgments are not to be read as provisions of the statute. So this is what is the review petition that the Honorable Supreme Court says. that the judgments or the observations in the judgments should not be considered as statute. Judicial utterances and or pronouncements are in the setting of the facts of a particular case. To interpret words and provisions of a statute, it may become necessary for the judges to embark upon lengthy discussions. The words of the judges interpreting statutes are not to be interpreted as statute. So they are saying that please don't make this judgment as statute, don't follow it as statute, as the provisions of the law, and please follow it based on the facts of the case. That's what finally held. The applicability of the judgment would depend on the facts and circumstances of each case, and for decisions to be binding for any other case, the court shall have to be satisfied that based on the facts of the decision of the Supreme Court in Vidarbha shall be applicable. The interpretation of Section 7 by the Supreme Court by itself cannot be looked at as provision under the code. So this is the judgment. And finally, day before yesterday, or I think 16th of January 2023, another judgment came, which was Maganlal Daga HUF and others versus Jagmohan Daga. In this again, the NCLT had relied upon the judgment of Vidarbha, and based on this judgment, NCLT in fact admitted some of the cases. Now immediately the Supreme Court has said that it has been submitted that the decisions in Vidarbha Industries Power Limited runs contrary to the settled provisions in the law laid down in Innovative Industries Limited versus ICICI Bank, and subsequently followed in several decisions of this court, including E.S. Krishnamurthy versus Bharat High-Tech Builders Private Limited. In this case, the Tushar Mehta actually appeared on behalf of the Union of India. Solicitor General of India submits that the principle which has been enunciated in Vidarbha Industries Power Limited is liable to dilute the substratum of the Insolvency and Bankruptcy Code. Hence, the notice is being issued returnable on 6th February. So that actually means that this judgment had come where the application of Vidarbha Industries Power Limited on other cases was challenged, and Tushar Mehta, I think representing Government of India, in fact gave a statement. And thereafter, after this, because this judgment is on 16th of January, and on 18th of January 2023, we had this notice from Ministry of Corporate Affairs, where the Ministry of Corporate Affairs invited the suggestions and comments on the proposed amendments, and it is one of the amendment in the notice that the impact of Vidarbha would be diluted. So I think we should not invest more time on this judgment. Coming to the next judgment is Kotak Mahindra Bank Limited versus Balakrishna and others. So this is a judgment where the assignment of the appellant was assignee of certain loans, and the compromise settlement was done, entered, and the DRT issued recovery certificate. So based on the recovery certificate in 2018, the appellant filed an application under Section 7. So the admission order was challenged before NCLAT by an order, set aside the admission order by holding that the admission application under Section 7 is time barred, and that the issuance of the recovery certificate. Now, finally, it was held by Honorable Supreme Court that the recovery certificate is a financial, whether recovery certificate is a financial debt, whether Section 19 subsection 2 and 19 subsection 2A of the Recovery of Debt and Bankruptcy Act restrict CIRP based on the recovery certificate. So it was very clearly said, like submissions of the appellant and the submissions of the respondents, we do not have time, but the findings we can say, what are the findings of the Supreme Court in this case? Recovery of the certificate is a financial debt within the meaning of Section 5 subsection 8 of the IBC. And in this particular case, the application was filed, debt, liability, everything was clear. And the list of arrangements were also there. The judgment, the Dena Bank judgment was also relied upon in this case. And the findings were, the Supreme Court held in this case that if the contention on behalf of the corporate debtor is accepted, it would render the very purpose of section 19 subsection 2A of the RDB Act. It was also further observed that the language of section 19 subsection 22A of the RDB does not suggest that it is limited to initiating winding up proceeding, because in this RDB Act, it is mentioned that in case of a recovery certificate, based on the recovery certificate, the winding up proceedings can be initiated against a company. So therefore, the recovery certificate as such is a document which actually can, again, the limitation can be started afresh from the date of the recovery certificate. If the recovery certificate is there, if the original debt is financial debt, the recovery certificate also would remain as a instrument for financial debt. If the original debt is an operational debt, then even the recovery certificate will also give a impact of a operational debt. Now, moving on to the other judgment, which is Ashok G. Rajani versus Beacon Trust Ship Limited. Again, a judgment was dated 22nd of September 2022, and this was again a settlement under section 12A of the IBC is pending before NCLT, and NCLAT stayed the formation of COC but declined to exercise its powers under Rule 11 of the NCLAT rules to take on record the settlement and dispose of the matter. In fact, in this case, NCLAT permitted the IRP to issue publication and hand over all assets and proceeds of with CIRP, even though the matter had been settled between the parties. Being dissatisfied by the order, NCLAT appellate had preferred the present civil appeal. Is there any bar on withdrawal by applicant of an application under section 7 on the IBC before the constitution of COC? This was the matter before the Honorable Supreme Court. So the Honorable Supreme Court finally said that section 12A of the IBC enables NCLT to allow withdrawal with 90% of the voting share. It clearly permits withdrawal. There is no issue in that. The question of approval of the COC by requisite percentage of votes can only arise after the COC is constituted. Before the COC is constituted, there is no bar to withdrawal by the applicant of an application admitted under section 7 of the IBC. Now, the observations further says the objects and the reasoning, IBC's maximization, the reading, all this is absolutely fine, but it is emphasizing that the withdrawal is a basic right of the company, and the settlement applications can be submitted at any point of time, even before the constitution and after the constitution. After the constitution, 90% is required. Before the constitution, 90% is not required. The withdrawal of an application by CIRP by the applicant would not prevent any other financial creditor from taking recourse to a proceeding under IBC. The urgency to abide by the timelines for completion of the resolution process is not a reason to stifle the settlement. So, like going forward, Amit Katyal versus Meera Ahuja, again, the judgment was March 2022. And in this case, the appeal was filed by the promoter or a majority shareholder, where the admission of CIRP was challenged. It was a housing project which remained incomplete for about 8 years, and the original petition was filed for an amount of about 7 crores due to an inordinate delay at the completion of the project. NCLT admitted the said petition on an appeal. NCLT is also upheld the order of the AL. Then the Supreme Court came, whereby the Honorable Supreme Court stayed the order of the commencement of CIRP, for which the CD had directed to deposit 2.75 crores with 6% interest. So what actually is it actually went to the Supreme Court, whereby the Supreme Court stayed the order of commencement of CIRP, for which the CD was directed to deposit 2.75 crore with 6% interest. The matter was adjourned from time to time. Meanwhile, the appellant entered into a settlement with the home buyer, who wanted possession in whose term, and the appellant would be liable to finish the project within 1 year and hand over the possession. Further, the appellant also agreed to refund the original petitioner 3.36 crore with accrued interest. The appellant approached the Honorable SC because this was basically Article 142 powers of the Supreme Court, and the Supreme Court, in fact, accepted the settlement and withdraw the CIRP. Not a judgment which can be applied to multiple cases. It was only Article 142 judgment of the Honorable Supreme Court, and they in fact thought that it was the greater interest of the home buyers that is more important rather than at point of time going through the process. So they used Article 142 and they in fact quashed the entire process, accepted the settlement, and the company went back to the promoters. Maitreya Doshi versus Anand Rathi Global Finance Limited, again September 22 judgment of Honorable Supreme Court. And in this particular case, it's like a case of, I believe, the Premier Automobiles. Doshi is the founder promoter of the Premier Automobile, where the Fiat and the Premier car we had enjoyed in many years of our life. So the 6 crores of loan was dispersed to Premier Limited, and the mortgage was created on the shares of Premier Limited, which was owned by Doshi Holding. So this is a case where it was a default by Premier, and the financial creditors called upon the Premier for non-payment, and on account of non-payment, finally the Doshi Holding was proceeded against. So the basic issue was before the Supreme Court, if there are two borrowers or if two corporate bodies falls within the ambit of corporate debtor, can proceedings under Section 7 of the IBC initiated against both? And the Supreme Court said, yes, it can be initiated both. In this particular case, the Doshi Holding was the corporate guarantor, and the security was also given by Doshi Holding. The loan was taken by Premier Limited or Premier Automobile Limited, which was the earlier name. Then both of them becomes the corporate debtor. So the insolvency or the proceedings can continue on both, and it is not restricted to one. So these observations are very clear that even in this case of Lalit Kumar Jain versus Union of India, it was also held by Honorable Supreme Court that the approval of a resolution plan in respect of one borrower cannot discharge a co-borrower. So in this case, both these companies can be proceeded against. So I would again take few minutes on this State Tax Officer versus Rainbow Papers Limited. Again, a judgment from Supreme Court in September 2022. The facts of this case was that the recovery was for the year 2011-2012, and the CIRP in this case started in fact, I have some more facts, which is like the recovery proceedings started in 2016, CIRP started in 2017, and the assets of this company was attached by the State Tax Officer during CIRP, and that particular matter was not highlighted, or that particular matter was not even agitated in any form by way of any appeal by the RP. So, but the RP continued the process, ignored the facts of the claim filing, attachment, recovery. All these facts were ignored by resolution professional, and therefore the State Tax Officer finally challenged the approval of the resolution plan, and then finally the Honorable Supreme Court held that this Section 48 of Gujarat Value Added Tax 2003 provides for a first charge on the property of a dealer in respect of any amount payable by the dealer on account of tax, interest, penalty, etc. So this cannot prevail over Section 53 of the IBC. Although Section 53 very clearly says that the secured or unsecured, there is a separate provision and there is a separate priority for statutory liabilities. It is very clearly stated that statutory liabilities or any amount which is payable to Consolidated Fund of India or Consolidated Fund of a state will have that fifth priority as per the Section 53. I think while giving this judgment, the Honorable Supreme Court, nobody would have presented that particular fact that there is a separate priority which is given in the Section 53, and there is nothing which is mentioned as secured or unsecured. And I have read the judgment completely, but this particular fact was not at all there. It was not provided to the bench by any of the lawyers. So therefore, the judgment came, and it was in fact said that whether the provisions of the IBC and in particular Section 53 thereof override Section 48 of the Gujarat Value Added Tax Act. So it is not really a question of overridden. It is only a question that the definition of security interest, when we see the definition of security interest provides for such kind of attachment. Now, finally, the definition of security interest was used for considering the dues of the tax as a secured operational creditor. And when we see Section 53, and in the very first line, it is where the priority after the CIRP cost or the liquidation cost goes to secured creditor. There is nothing written there whether a secured creditor should be operational creditor or it should be a financial creditor. That means the secured creditor can be anyone, financial or operational. In fact, I was handling a couple of cases where the electricity department had a lien on the property of the user against the dues. So we had considered them as operational creditor and given them the security interest, and we allocated them proportionate to the other secured creditors. So they were happy. Similarly, the state industrial development corporations, they also used to file their claims regarding some dues, and in their agreement and all the leasehold agreements or all even the freehold agreements, they have a prior lien on the property in case their dues are not settled. So we also have considered some of the state industrial development corporation as secured operational creditors, and we distributed them proportionate to the secured creditors. They were happy. So this kind of scenario we in fact used to do before also. However, when this judgment was being, I think, argued, nobody brought to the knowledge of the Honorable Supreme Court bench that there is a Section 53 special provided clause, and that clause doesn't get changed. It is not a question of Section 48 of the GVAT Act, whether it overrides or not. They have not used that. They have only used that the secured operational creditor because of the lien on the assets. So I think this is also being diluted. This is also being diluted, and in the proposed amendment. So therefore, like I definitely would say that these two judgments are being diluted, and there are many other amendments and which actually would have a wonderful impact on the IBC, and especially in those cases where the information utility is being made as a kind of warehouse of all the defaults. So in case your default is warehoused in the information utility, then there is no other requirement of any kind of adjudication of debt and default, because that the adjudication of debt and default is being shifted to information utility. Suddenly you will see that the information utility has become very, very important in this country. So I think this Ruchi Soya Industries Limited versus Union of India is another judgment which is almost contradicting to the Rainbow paper. Ruchi Soya came in the February 22 and the Rainbow came in September 22. In Ruchi Soya, the first fact that you must know that there was a notification in June 2002 when a lot of people in India was importing palm oil. So the government of India, in fact, issued a notification that on import of these palm oil, there will be some tax which will be imposed by the customs department. Ruchi Soya industry somehow was importing palm oil those days. So Ruchi Soya Industries, in fact, came into this notification, and the Ruchi Soya industry were issued a notice for imposing the recovery of this kind of tax. Then it actually went to the High Court, and then finally it came to the Supreme Court, and Supreme Court finally said that if you deposit this much of amount, we will grant you stay. So in 2012, a stay was granted to Ruchi Soya against the payment of tax. I'm not sure it was full payment or part of the payment. And then the matter was quiet, it was stayed, and there was nothing happening in this case since 2022, when this Ruchi Soya resolution plan was approved. The resolution plan was approved. In fact, the NCLT in 2019 approved the resolution plan of Ruchi Soya when it went to Pitanjali. And in February 2022, this matter came up again before Honorable Supreme Court regarding that matter of the tax dues from the Custom Department on the import of palm oil. That's substantial amount, I believe. Now, in this case, since the amount was already paid by Ruchi Soya, the Custom Department did not even submit their claim of the dispute which is pending in the Supreme Court. Custom Department was sitting pretty okay because they had received the amount in their account. Now, in this case, the claim was not filed. So the issue which was settled by the Honorable Supreme Court, whether all claims stood frozen and no claim which is not part of the resolution plan would survive. So finally, the Supreme Court said that yes, in case the claims are not filed, the claim will get frozen, and no claim can be filed after the resolution plan is approved by the authority. And in this case, it was also held, since there is no claim, and then they also relied the judgment of Ghanshyam Mishra, where the claim which was made by the unit was not part of the resolution plan and hence does not survive, and directed that the amount deposited. Finally, what was the claim was considered to be a nil, and whatever amount was deposited by Ruchi Soya on the directions of the Supreme Court, that was refunded to Ruchi Soya. So this is also considered to be a windfall for Pitanjali, because they had never factored into this particular windfall in their resolution plan. So because of the claim of the Customs Department was not filed in the CIRP process, and the claim became nil, and whatever amount was deposited, that became the asset of the Ruchi Soya, so it was given to the successful resolution applicant. So these are the kind of judgments that we are trying to see, and this is again, I don't think this is very important, because this is a judgment of Bank of Baroda versus MBL Infrastructure Limited. This has got no application nowadays, because this was basically a judgment which started at the time of insertion of Section 29A to the Act. So I don't think this actually will have any impact. Although in Supreme Court said in this case that these promoters were not entitled to submit a resolution plan, and the NCLT and NCLAT should not have approved their resolution plan. But now, since a lot of water has flowed under the bridge, the resolution plan has been implemented for 4 years. The company is in fact survived. The company has again doing a lot of turnover, and all the employees have been reinstated. So they don't want to interfere. So that's a different kind of judgment. However, this India resurgence...
Mr. Anil Goyal, I'll just take a second. That yesterday I've got an order from NCLAT exactly on MBL. And I was just sending a message to Nilesh that it's an interesting judgment which I got on 29A. It was challenged and I took an opinion from Nilesh, and a beautiful judgment. I'll forward it to you and maybe you can discuss it also. It talks of Section 24 and 29A and refers of MBL judgment and its interpretation.
Now in MBL judgment, the Supreme Court in fact had held that this resolution plan should not have been accepted from the promoters, which is some Mr. Anjani. And then it was also said that since a lot of things have happened, we don't want to disturb the entire process which has been conducted 4 years back. So therefore, we don't want to interfere. And I think, as you say, still in case there are some old cases lying, it will have the same fate.
There was an appeal filed in January 21 against the plan where I was the RP, and the resolution plan filed by an associate company which was related was approved by the COC, and somebody went for an appeal, and NCLAT has given a beautiful judgment that I can give it to a related party because, and there were guarantee issues. Please read it and then we can have a debate. Said excellent
I
judgment.
think I still feel that I have 10 more minutes, and I would be rather interested in case there are some questions which are coming from the floor that actually would be that will make this entire effort more fruitful.
Maybe if you have one or two more judgments to share for our learning, we'll be happy, and then fine.
I think I can continue to share my judgments. That's something which is that makes me happy also. But see, as far as this India Resurgence ARC Private Limited versus Amit Metallics Limited is concerned, where the VSP Udyog Private Limited was the corporate debtor. So India Resurgence had a security value of 12 crores, whereas in the resolution plan, India Resurgent had only 3.94% voting share, and the resolution plan offered only about 2 crores to this India Resurgence, and the resolution plan was approved by 95.35%. So in this case, basically the Supreme Court held that the dissenting creditors will get the same kind of amount which the other secured creditors are getting. They did not relate the liquidation value of the dissenting creditor separately based on their value of security, because otherwise also this dispute is pending before Honorable Supreme Court whether under Section 53 the secured creditors will be considered based on their priority and based on the value of the security that they are holding. That matter is still pending. So far, even the Amit Metallics and the Technology Development Board versus Anil Goyal, both are indicating that the dissenting creditors will also get proportionate to the secured creditors and not based on the value of the security interest. So this is what is the India Resurgence. India Resurgence doesn't say that Section 30 subsection 4 is mandatory. It says that the Section 30 subsection 4 is a guidelines to the Committee of Creditors. However, the commercial wisdom of the Committee of Creditors in this case has been upheld that they can offer any secured creditor even proportionate also and even higher also based on the value of their security interest. However, under Section 53, what would be due to a dissenting creditor, that is still not decided. So therefore, the Amit Metallics, the India Resurgence case, that is based on one particular matter that the secured creditors will get proportionate. So that is the judgment of India Resurgence. So we can actually, there are many judgments that we have as the like the corporate grunters. So in this particular judgment, which is the judgment of Parma Sivam versus Karur Vyasya Bank, September 22. It looks like as if September 22 was the many judgments were delivered by Honorable Supreme Court. So in this case, the three borrowers, Shri Maharaja Refineries, Shri Maharaja Industries, and Shri Maharaja Enterprises, these were either the proprietorship concerns or the partnership concerns and had taken loan from the banks, and the main company Maharaja Theme Parks and Resorts, that company had given the guarantee. So the no loan was taken by this Maharaja Theme Parks, the loan was taken by the other three companies. And when this the default occurred, the Section 7 application was filed against the Maharaja Theme Park. So this was the basically impact of the, then finally it was held by the Honorable Supreme Court that the lenders have the right to proceed against the corporate guarantor or the borrower or both. Earlier also we have seen that we can even proceed against both or we can proceed against one. or we can proceed against anyone, whosoever, even if the person is not a borrower, we can even proceed against the grantor. So the Lakshmipat Surana versus Union Bank of India was another earlier judgment which was delivered in March 21 by Honorable Supreme Court. It was the similar judgment as we have seen in the Lakshmipat Surana versus Union Bank of India. And then we also have seen this Sandresh Bhatt, liquidator of ABG Shipyard versus Central Board of Indirect Taxes and Customs. In this case, the ABG Shipyard imported certain goods, and the goods were lying at the custom, and the custom duty was not paid. Now, when a person imports, the invoice was made in the name of the ABG Shipyard. That means that the goods are owned by ABG Shipyard, irrespective of the fact whether it is paid or not. So the custom duty is not paid. So the liquidator applied to the customs department that you release the goods to us and you file your claim. It was not done. Then the liquidator filed an application to NCLT. Then the claim was also filed. And finally, it was held by the Honorable Supreme Court that the customs would not override the IBC. The custom department will submit their claim and that will be dealt with under Section 53. However, the goods, whatever goods have been imported by the company, that is owned by the company, and that should be handed over to the liquidator. Third, it was also held that the custom department does not have any power to sell the goods and recover their custom duty as per their own law. That was the decision in this case, and that is a very, very good decision, and it actually has worked well in other cases. We have also taken the help of this case, and we have also got many assets released from customs department. Also, in this Indian Overseas Bank versus RCM Infrastructure Limited, the case is like this, that this Indian Overseas Bank sold a property of the company, took 25% and issued the sales certificate. In between, CIRP started. Then the Indian Overseas Bank took the balance amount also 75% after the CIRP started, and Indian Overseas Bank in fact argued that the sale was concluded before the CIRP started and this is not impacted by moratorium. And finally, the Supreme Court said yes, the issue of sales certificate without payment is beyond the acceptability as under the SARFAESI rules. SARFAESI rule says very clearly that full amount will be received and then only the ownership and the sales certificate can be issued. The sales certificate was wrongly issued. The transaction under the SARFAESI was not concluded. Therefore, the bank has to give this money back to the resolution professional, whatever they have recovered, and they will file their claim for the full amount. And this amount will also become part of the resolution process or the liquidation process. So again, this Asset Reconstruction Company India Limited versus Tulip Stars Hotel Limited. So these are all on limitation law. There are many judgments on the limitation law. Now, the limitation law judgments, I can frankly say, I can just name the judgments and I can say that these are the judgments which are again the State Bank of India versus Krishidan Seeds Private Limited. This is again on Supreme Court judgment on the limitation law. So what are the judgments on the limitation law now? First of all, this section 238 capital A was inserted where the limitation law was applicable as the case may be to the insolvency proceedings. This was the number one amendment. Number two amendment, that any acknowledgement of the debt would become the will be a renewal of the document and the limitation period will start again. Then the third judgment came that any kind of acknowledgement, even by way of a email or even by way of a settlement agreement or even by way of an OTS proposal, that also would be considered as acceptance of the debt. Then the judgment came that any payment made in between or any PDC checks issued or any checks bounced, that actually will be kind of the acknowledgement of the debt and the limitation period will start again. Then the judgment came that any kind of acknowledgement in the balance sheet of the debt, So finally another judgment came from the Supreme Court, which says that the unqualified acknowledgement or entries in the balance sheet. Then a judgment came that the entries in the books of account also would be considered as acknowledgement. So now the limitation law has actually been completely settled. All these kind of things that I have stated, these are all out of the limitation law. But this particular judgment, which is on the screen, Sapphire Technologies Private Limited versus Regional Provident Fund Commissioner, this says that the NCLT has no power to accept a appeal beyond 45 days from the date of the communication of the order of the adjudicating authority. So the original number, the actual is 30 days, 15 days is the grace, which is within the powers of the NCLAT. Beyond that, NCLAT doesn't have any power for condoning the delay in filing the appeal. Now, in this case, there's another limitation period, which I would say that in case the company, now think of a situation that one company has been taken over by another person, under a resolution plan. Now, when he looks into the books of account, he finds that there are certain receivables which can be recovered. And then he finds that most of these receivables have become time barred. So this particular judgment is in April 22 says that because it's section 60 subsection 6, the section 60 subsection 6 is used in this case, which says that any period of moratorium that would be excluded for the purpose of limitation for the recovery of any dues by the corporate debtor. I think this is also very, very helpful for any resolution applicant who will find the books of account and say that this is the kind of dues and those will not be time barred. So this is also a balance sheet entry. The balance sheet entry is a balance sheet entry that could be treated as a kind of writing under section 18 of the Limitation Act. Again, the dispute under section 9, in this case, the SS Engineers versus Hindustan Petroleum, the fact was very clear that the NCLT said that the section 9 application can be admitted because the total amount dues was, say, for example, 10 crores and the dispute reported was only for 2 crores. So therefore, the NCLT said that this application is admitted. However, the NCLAT said that it is not the jurisdiction of the adjudicating authority to decide about the disputes and to settle how much is the disputed and how much is the payable. And the simple thing that the NCLT was supposed to see whether the dispute is there or not. So that's what the Supreme Court held. The Supreme Court said that it is not the duty of the NCLT to adjudicate. It is not the duty of the NCLT to adjudicate the dispute. So if there is a dispute, the application is liable to be rejected. I think that these are the limitation judgments. And one important judgment I would, again, limitation, after the limitation, the commercial wisdom. In the commercial wisdom, it is again the COC has the commercial wisdom, 90% people can vote and can withdraw. And this again, Noida versus Anand Sonbhadra is that Noida Authority, Greater Noida Authority, they are the operational creditors, they are not the financial creditors. And finally, the fee of the RP, NCLT and the NCLAT, they have no power to adjudicate about the fee without any rationale. There has to be a rationale. It cannot be kind of ad hocism would not work. When there was an agreement between the bank and the IP that this is the fee and that agreement should be adhered to. After that, the adjudicating authority and the appellate authority should not delve into the reasoning. So that is what was the judgment. So there are, in fact, because of the time constraint, and I had to just run through, but yes, we can still take up 1 or 2 questions, and then I would have to go for another judgment. Yes, over to you, Manoj ji.
Yes, please. Yeah, if any audience is having any question. Okay. Sir, you discussed.
I have a serious issue.
Yes,
I have a serious
Yes, sir. Yes, sir. Please, Sharma ji, please carry on.
With regard to the settlements, when the applications are filed, because in many cases, in particular of real estate, we have seen that after 4, 5 settlements, 6 settlements, ultimately the CIRP gets admitted. And those settlements go into PUFE. And it is actually an inordinate delay in initiating of CIRP. Something should be done that these settlements should not be allowed very easily in potentially sick or companies which will in near future go into CIRP. Something should be done, some regulation or some such action should be taken. In one of my matters,
I think, Sharma ji, this is a normal discussion. I can understand. And when this colloquium happened for 2 days, and this was also a very large discussion, and it was almost everyone's opinion was that we should not try to resolve the recovery issues within the CIRP, within the adjudicating authority. If there is a default, they should immediately order for the CIRP and let them settle. But while the application is pending, there should not be any settlement process in the court. That's what was the opinion given in the colloquium by everyone. And I think some kind of regulations also would be made post this amendment to the IBC. So everyone now understands that it is not the duty to settle the disputes in the IBC, but they would like to, in case there is any application, it should be immediately, it should be kind of CIRP.
right. My comment is the judgments you have given in section 12. So
Yes, yes, yes.
you are right.
So I think I have to seek apologies for leaving this webinar. And Manojji, by conveying my thanks to you, conveying my thanks to IPA and the organizers, Nilesh, my brother, and for the active participation by Shivnandan Sharma ji. Thank you very much. Thanks a lot. Thank you, ji.
Thank you, sir. Thank you very much. In fact, we are indebted to you for sparing your time. You know, we all can understand that how heavily you are poised even for today. Despite that, you honored, IPA and other organizations by giving time of 2 hours and like that. Sir, before we end, part way with you, so as we discussed together that notification, from the government of India, which has come out to be their points related to the IBC amendments, which you also taught. We thought of taking it on coming Saturday. So, sir, what I'm feeling is that on Saturday, many, the things are happening as far as webinars are concerned, and this will also be a very hot topic. If we can take it during the week, say on Wednesday, Thursday, something like that, so that, we can have the good audience also. And secondly, it's a new topic for everybody, and we can do it like that also. So, sir, please plan and if possible, spare some time for that particular thought.
We can plan that, not a problem. We can plan.
Yeah, sir. We shall talk
So
personally
we'll talk about it and we'll plan it accordingly.
Yeah, instead of Saturday, which we talked, my humble submission to you is that let it be done early.
The only difficulty during the next week is that the 26th is a holiday and 28th is a fourth Saturday, 29th is a Sunday, and in between 27th is one leave that the people will actually take 4 holidays out. So we would only be left with 23, 24, and 25. Or alternatively, we do it on 26 in case people are happily joining on a holiday. I'm not sure whether they would like to do a professional work on a holiday. But anyway, we'll decide it later. But then this is a very important thing that we have to do. And so we'll discuss and we'll decide about it. Right, Ji?
Thank you very much. Thanks a lot, sir. We shall decide it on one-to-one call. Thank you, sir. Thank you for sparing your time. IPA is absolutely indebted to you. Thanks a lot.
Thank you, Ji. Thank you. Thanks a lot.
Okay. Shivnandan ji, we are so enlightened with your participation and active participation that I would like that in the coming webinars, I shall talk to you one-to-one also, and you will also take some topic to enlighten VIPs. So, sir, आप अभी से उसकी तैयारी करना शुरू कर दीजिए, and we would love to hear from you also.
I would actually like to answer the queries, and in fact, if you incidentally know that I am the critic author of the code and participated right from the day the first white paper on bankruptcy was presented to Manmohan government, that how it should start, and then writing the act. I would actually like to answer queries if people have, rather than coming into. So we can actually hold a query session where the participants ask question and a group of professionals can clarify their queries or tell them how to go about their work.
Okay. We talk one-to-one and then accordingly decide how we can, mingle like a query session with our main session like that. Okay. Now some adjustments are left here, which I prepared for for all the IPs. I'm moving to my presentation and would be sharing those presentations. Would be sharing those judgments with you. Is my screen visible now? I'm asking,
Yes,
is my screen
yes.
visible?
Yes, it's visible.
Okay. Yeah. Okay. We have discussed Hirakund Industrial Works already. Right of particular secured credit to proceed case. Okay. Now this particular, my point number 3 is, Ujas Energies Limited. Whereas I just go to the details. In nutshell, this is the judgment that won't serve any purpose. In this particular, what happened that secured creditors passed a resolution plan, whereby in that particular resolution plan, they declared that no proceeding by a particular secured creditor shall be done against a personal. Grab it under the commercial wisdom, which NCLT Indore bench struck down and said that such site of resolution plan is not a commercial wisdom of the COC and it can't be implemented. And hence, this is one of the judgment in the case of Ujas Energies Limited, NCLT Indore bench. Okay, my 4th judgment is Shriram Infrastructure Limited versus SREI Equipments Finance Limited. In this case, what happened? This is again an order. I just shared briefly with you. I have taken this judgment for another purpose, that it has been held that adjudicating authority with reasonable cause can take steps to remove the resolution professional, especially when he is not taking steps to hold a COC meeting despite directions by the stakeholders. My only question is there that many a time it happens with us also that we want to get rid of it, that particular assignment, but we don't have any right to do that. In my opinion, we should also be given a right, if we are not satisfied with the particular case, a particular assignment, we should also be given a right to resign also. And what my fellow the IPs say on this account, please? Any opinion on that? In fact, I would like to share with you that in one of my friends who's holding this particular assignment, I would name the case, that is a pioneer case. In that particular case, some employees said that हम आपके केस क्या कहते हैं आने वाले दिनों में ये धरना दे देंगे पार्लियामेंट के बाहर या इसके नॉट पार्लियामेंट के बाहर बट ये दिल्ली में पर्टिकुलर जगह पे बिकॉज वी आर नॉट हैप्पी विद योर परफॉर्मेंस. तो इस तरह की जब सिचुएशंस हम लोगों को फेस करनी पड़ती है, there may be some other reasons also, we should also be given a right to resign.
No, like Manojji, I have said that at least after the resolution is over, an IP can surely decide that whether he will decide, because in one of my matters, I refused to be part of the monitoring committee. And its monitoring committee is a very easy job. You have to only monitor implementation of the plan and you get a fair fee. If you take the fees that were allowed all time, 2-3-4 lakh rupees की fees आप monitoring में ले सकते हो. But I refused. In another matter, I refused to offer myself from appointment of RP from IRP. So these two windows are available to you. When your IRP period is getting over, you may decide that I will not offer to become RP.
Sir, I agree with you, because at that time you are supposed to give your consent in form number 2, and if you don't give the consent, then automatically it
And
is
you
over.
tell the COC that I am not interested because of my personal reason, which you need not define. So there is only one window, but I agree that an RP should be allowed to resign or leave an assignment without any problem. In one of the matters where Canara Bank had called me to take up an assignment where the RP was not well and due to health ground he wanted to leave. That can happen, but otherwise I don't think that there are provisions where an RP need not say that I will not be able to do an assignment. I have one matter where,
Sir, there.
Manojji,
I have
can
one
I
matter
can I
before-
interrupt?
I have
Yes,
one matter
yes, please,
where
please.
I have been appointed after the resolution was admitted, and I was appointed by the tribunal after 400 days. But in this particular matter, the RP did not do any work. He did not even, after getting the order, he went to sleep. He did not give an advertisement. He did not do anything. He did not write to anybody. And after 400 days, the NCLAT ordered that you appoint a RP because it's a difficult assignment. He practically abandoned for some personal reason, assignment being very tough, where, I mean, similar situation, dharna de denge, ye kar denge kind of. So, but it's not easy for an RP to leave an assignment once taken.
No, I beg to differ. I think there is a little bit difference of opinion. I come across again where IRP was confirmed as an RP. He confirmed as RP in 2 cases he was having. And thereafter he had certain problems with some third party. So he tendered resignation and it was put before COC. COC has considered it and COC said that we will appoint a new RP, and they put my name in one case and someone else in another case, and they made an application to NCLT, and NCLT has agreed it, and thereafter we become the RP of these 2 cases, and we continued and completed the cases. And when the resolution plan was also came, resolution plan was also implemented. Today the implementation is in the final stage. So such things is possible that with the approval of AA, is it possible to change the RP also?
Abhiji, I appreciate your saying, but what we were discussing, what me and Mr. Shivanathan was discussing, that there is no such provision in the law. You've been able to root through your your another RP has been maybe able to have been root through resolution, and that process is there. IBBI regulation clearly prohibits any IRP, RP to, especially the assignments which are given by the NCLT directly, to leave aside those assignments. There is no such provision, there is no such regulation, except on the health ground. That might be an exception there, but there is no other reasons there. What we from our webinar through our webinars is being seen by the higher authorities also, we beg and say that let that sort of provisions be inbuilt therein, maybe because of low remuneration, maybe because of more tension, maybe because of some dharna or some sort of other things there. Because अब देखिए शादी आदमी करता है, वहां पे भी तो डिवोर्स होता ही है ना, डिवोर्स के प्रोविजन है ना इस कंट्री के अंदर. Similarly, we want also that some sort of regulation be there for the benefit of IPs. That's all.
Now, what you say is absolutely right. Regulation should be there, but here it is only the basic principle of the law is that wherever it is not specified in the law, where we have to go to NCLT and get it approval, and that's how it happened, and this RP was changed. Now coming back, as far as we are concerned, we senior RPs are concerned, we should certainly make an application, rather recommendation to IPPA and IIIPA that such things also should be considered, because why RP should be compelled to continue the assignment where he is not interested for whatever reasons. He may have his personal ground also, other than health ground also, he may have some personal ground also.
Yes, yeah. We now we all are, me, Mr. Shivnaranji, and you reached to the same path what we were talking to. Now let me move to my another judgment.
Okay. Okay. Now it's okay, perfectly okay. Now let's continue on the subject. Thank you. Thank you.
Yeah. Okay. Now, one thing, my fifth judgment, which I would like to, discuss is that we understand that under Section 14, moratorium is there. In that case, in that moratorium, no cases can be filed against us. But I come across in one particular case, whereas I would like to enlighten my fellow brother that there are two exceptions where, despite moratorium, cases can be decided. One, that particular provision is provided under subsection 3 of Section 14. One is A and another is Part B. E is that whereby central government has been given power to, not to apply this moratorium. But second one is more important. That is Part B, a surety in a contract of guarantee to a corporate debtor. Meaning thereby that in this particular judgment, let me move to the judgment. This is a case of IDBI Bank versus Indian Oil IOC. What happened in this case is that CD banker has given guarantee on behalf of the CD, and that guarantee was revoked by the beneficiary. And the matter went up to NCLT, and NCLT held, because of the amended provision as on 28th December 2019, this guarantee can be revoked, meaning thereby that moratorium in case of revocation of guarantee is not applicable. Let's understand this thing. That was my purpose of sharing this particular judgment. Okay, another judgment is, I'm taking it briefly because our time is already exceeded. Talbot and Company versus Austin Distributors Private Limited. In this case, it was held that disputes pertaining to contractual issues are not to be resolved in IBC. Section 9 proceedings in this case was nullified based on this thing that commercial disputes cannot be decided between by IBC. My last thing is that, I would like to update very famous case of Gurmeet Sodhi versus Union of India. It is taking a lot of call for all the personal guarantor cases. Before I, give you the update, I just share about this particular case because this is a very important case. What is happening is that earlier in case of personal guarantors, Lalit Kumar Jain case was there. Lalit Kumar Jain case decided the applicability that the personal guarantee can be revoked against the directors and other things there. In this case, what happened is that subsequently, in the case of Gurmeet Sodhi, who was a personal guarantor to a corporate debtor, he challenged the proceedings of that particular chapter, whereby personal guarantees are there, like section, I think 92, 93, 94 is there. I just remind you that in case of personal guarantee, we have two sort of the types of application. One is under section 94, another is under section 95. Under section 94, this application is filed by the personal guarantor himself. Under section 95, this application is filed by the financial creditor. So when as far as the process of the personal guarantee is concerned, the moment you file the application, the moment it is accepted by the registry, the interim moratorium starts, partial moratorium starts, full moratorium starts when section 99 application is accepted. Mr. Gurmeet Sodhi challenged this thing that you proceed against us. Financial creditor files an application under section 95 and court SEPTA, also SEPTA application, this thing. But in the whole process, we are not being, asked. So it goes against the natural justice that without asking us, you are treating it as a defaulter. So up now, what is happening is that in this case, a lot of people against whom 95 section applications were already filed, they have gone to the Supreme Court, and they are praying that we are challenging the validity of these particular sections, whereas natural justice is being eluded to us. Accordingly, Supreme Court is taking all these applications. And what was happening earlier was that the Honorable Supreme Court was granting stay against those proceedings also. But lately, now when this IBC is being taken care by our Honorable Chief Justice of India, this particular stay is not being granted. Only the things are being, attached there. But it has an, otherwise effect on the NCLT. What NCLT benches are starting doing is that, let's talk about the principal bench Delhi first. Before that, I tell you that around 200 or maybe 200 plus petitions have been tagged along with this Gurmeet Sodhi case. And what NCLT benches started doing is that, first of all, let's talk about the principal bench. What principal bench is doing is that, if in a particular day there are 20-30 cases related to section 95, 99 or 94, in bulk, they are giving a date without hearing, and after 1 or 2 months, and because they are simply waiting if what Supreme Court outcome will be there, whether the legal validity of these sections is held or not. If held valid, then only then we shall take a cause of this thing. As a result of which, all the proceedings are being delayed, or the recovery process of bankers or maybe other creditors also, that is being hampered. In some of the NCLT benches, they might be deciding the cases, but whenever there is any opposition from other side, other stakeholder, then they also not deciding. So this particular case is has a very, very importance as far as personal guarantees are concerned. So Supreme Court last heard it on 24th. And now, last heard it on 17th of January, but Supreme Court is also aware of this fact that around 250 application on a particular ground is annexed with it. And they have given on a very short date on 24th of January. And most probably, maybe in that date or maybe in the next date, this matter may be decided. And then it will, we shall came to know whether the personal contributions are as per law, or it is infringing what we call it is infringing the rights of the personal creditors. This is all. I was having only all this thing, nothing more than that. And now we can have discussion if there is any among all we members, or if any question is against my presentation, then I can be asked for that also. Anything else anybody would like to share with us? Dheerajji, now you can take and close down the meeting. Mr. Anilji is not there, and had it been there, then we should have asked him. Thank you also. Or if you want, you can also share some of your thoughts on today's presentation.
Yes, today's presentation is wonderful. Mr. Anil Goyal sir and Manoj Kumar sir has explained very well the recent case studies for the benefit of all the participants. So we wish the IPA should always on within a week time organize such wonderful seminar for the benefit of all the participants. So these all are from my side. Thank you. If you have
thank you very much, especially Shivnandar Sharma ji, who enlightened with his experience and all this thing. Thank you very much. With this, Abhay, would you like to say something?
No, nothing. I would like to say thank you very much, Manoj ji. You had explained very well. Even Anil ji was an excellent presentation. It was done. It was too enlightening for all of us. And I think please keep on sharing your knowledge and let's have the sharing with each other. Thank you very much.
Thank you very much. We are also elated with your experience. If in the days to come, if I come across that particular situation, if any of my colleagues come across that particular situation, definitely we shall knock you again and trouble you for that particular judgment.
No need of troubling, yeah. You are right. We are
Thank
all
you very
colleagues.
much. Thank you very much.
Thank you very much.
Yeah. Thank you very much. Thanks a lot. Thank you, everybody.
My pleasure. My pleasure.